Good morning, everyone. So for those of you who don't know me, as well as being the managing partner of our Guernsey office, which employs about 140 odd people, I'm also head of our employment team. And so that's probably why Susie gave me the title of Employment Law, Is It Fit for the Future of Work? And the answer is no. So we can all go and warm up now. No, okay, that's a bit too pithy even for me. So I decided I had to ask myself a whole series of questions in order to inform myself about whether or not it was fit for the future of work. So the first question I asked myself, and I admit it is a bit of a lawyer's exam question, is what is law's purpose? And so I spent quite a lot of time looking at the sort of psychology behind law, how it's made, and it's some quite interesting findings in that. Then I asked myself, well, who decides what the law is going to be? What does our employment law look like at the moment? And I have focused on Guernsey because it's the jurisdiction upon which I advise, but I suspect it's reflective of a whole bunch of other areas too. Then I asked myself, well, in that case, what changes need to be considered? And then actually, does law change the way we work? And then I've got my conclusion. So I hope I will answer the question, is it fit for the future of work? I think I'll come to the same answer, but just with a bit more development. So the first question I asked myself, what is law's role? Well, the ambition of legal regulation is to change behaviours, to increase or decrease various activities. So, for example, stopping the termination of employment because somebody's got themselves pregnant, or banning smoking in the workplace. But how does law do this? Well, it does it a number of ways. It does it directly through sanctions. So the threat of a sanction prompts individuals to take a risk-based analysis about whether or not they're going to engage in that prohibited activity. Shall I do it and get a fine, or shall I not do it and not get a fine? But also, it changes behaviour through changing attitudes about those regulated behaviours. So it recharacterises behaviour previously thought as harmless as being harmful or morally wrong. So let's use smoking again as an example. So in the olden days, my children think I come from the olden days, but I'm talking older than those olden days. When we look at those black and white pictures and films around the Second World War, smoking was a popular pastime. It was encouraged for health reasons. Then we moved on to a time when smoking's rep changed, let's say, and it became a personal risk-taking for consenting adults, or in my case, cool teenagers. But then we had what was called the Roy Castle effect. Now, for those of you who are younger members of the audience, or not from the UK or Guernsey, who was Roy Castle? Well, Roy Castle was a jazz trumpeter, and he was also a very, very popular children's presenter of the Guinness Book of Records. And in fact, he held 9 Guinness records himself. He was the world's fastest tap dancer for a while. But anyway, this very popular character, who had never smoked, contracted lung cancer through second-hand smoke in jazz clubs. And this drove a public campaign to ban smoking in public places, primarily led by his wife, but all sorts of celebrities and other people got involved. And it was a very, very efficient and proficient campaign. So in the employment context, although by the time that the law came in, many workplaces were smoke-free, I can certainly remember in my first job, people smoking in the workplace, it led to a law banning smoking in the workplace. In fact, a law that came in here before the UK. But then that in turn reinforced attitudes towards smoking. So frankly, if you lit up now a cigarette in a children's nursery, your health would be seriously impacted, and I don't mean just from the cigarette smoke. Law has made it a more undesirable behaviour. It's less convenient, so people can be persuaded to do less of it. Now, research shows that initially those changes are solely behavioural. And during this period, conventional law and economics will explain those behaviours, going back to the I won't do it because it will cost me money. But along the way, attitudes about morality also get altered. I won't do it not just because it will cost me, but actually I won't do it because society will judge me for it and my reputation will be impacted. And then there's a further shift to that's just not what I do. But for attitude to change, what's interesting is that the research shows that it's important that the individual perceives it is the product of their own decision making. So in order to shift from a I won't do it because I don't want to get fined, to I won't do it because I'll get judged, or I won't do it because it's not what I do, it has to be the individual who appears and perceives himself, him or herself, to make that decision. And that in turn decreases the harmful behaviour. So it has to be more than just the legal stick to be beaten with. Consider the examples of diversity and inclusion policies. If businesses consider their rivals are pushing the D&I agenda harder and getting greater kudos from it, and I just had a quick shifty at my mobile phone before, and I saw on the front of the global legal press, Linklaters were boasting about how many female partners they had in their most recent partnership round. It is more like, and if other law firms think if Linklaters do it, we need to do it, they will also push harder in that area too. There are the legislators themselves, elected representatives in a democracy who are elected to represent the public, so we have an influence as members of the public upon them. There is, of course, the government, who will typically be the prime promoters of a particular piece of legislation, again, reliant on the public in order to receive their guidance. The politicians' constituents who may have voted for them due to a particular policy promise in that legislation. There may be international pressure to bring in legislation. That's why the data protection law change, it's happened because of that international pressure. There will be powerful pressure groups who will seek to influence those legislators, periods of consultation where the public and industry bodies are asked. But perhaps one of the most powerful influences, of course, is the media, and increasingly the social media, whether or not they in turn realise that they too are being influenced or not. Again, interestingly, there's all sorts of research which shows that people's public opinion and private opinion are often very different. What they'll say in public and what they'll say to each other in private can often be poles apart. So that might explain why what someone might say in an open forum or to a pollster may be very different to what they'll say in the comfort of their own home. And their comfort of their own home will include their social media posts. So that produces a very interesting new dynamic. Who else is involved in that law? The drafters, of course, in our case the law officers, who will decide what words go on the page and can influence what priority that piece of legislation has. So as a new piece of legislation goes from concept to the law, there are thus a multiplicity of opportunities for the law to be thwarted, delayed, amended, approved, improved. But ultimately it is the legislator who will vote a new law through and who will be motivated to oppose or support a proposed law. But of course it's not just about the legislative body. Another part of the law matrix are the courts and tribunals who interpret and sanction the law. Now, unlike in places like the US, the judiciary this side of the Atlantic are not openly political. They are not political offices, although they are not immune to their own societal and cultural influences. As the Master of the Rolls, Lord Newburgh, argued, if women are not less good judges than men, why are 80 to 90% of judges male? It suggests, purely on a statistical basis, that we do not have the best people, because there must be some women out there that are better than less good men who are judges. This report also went to say, justice, fairness and equality are central values in the law which should be reflected in the composition of the judiciary itself, and perhaps the panels, for example, on the future of law. Judges are independent of Parliament and the executive, but they should not stand apart from the society in which they adjudicate. The public must have confidence in the judges who make the decisions which affect their day-to-day lives. As Lady Justice Arden argued, people may well have more confidence that their concerns have been taken into account if the judiciary reflects more of a cross-section of society. So, what does our employment law look like in Guernsey? Well, I think we'll call it employment law light. We have 5 main pieces. The conditions of employment law, that's the law that covers the terms which need to be included within your contracts. The Employment Protection Guernsey Law 1998, as amended, which provides for statutory notice periods and protection against unfair dismissal. The Sex Discrimination Law of 2005, which protects against discrimination on the grounds of gender, marital status, pregnancy and maternity leave. The Maternity Leave and Adoption Leave Law of 2016, it is what it says on the tin, and the Data Protection Law, which I've tried to thrust in just because we needed more than 4. Now, that's not to say there aren't other laws which influence the workplace, such as health and safety laws, but we have nothing compared to the many pieces of legislation in the UK. Interestingly, from the time of the billet d'état back in 1995, which brought in the unfair dismissal legislation, there's an expressed need by the legislature for Guernsey's employment law to be non-legalistic, and this has been repeated on each significant amendment. Now, this has always appeared to me to be an oxymoron. Can you have a non-legalistic law? But having said that, it doesn't mean it hasn't been successful in creating an environment where the performance of the employment contract and the protection given to the parties as one party to that contract is very different from almost any other contractual relationship. So, what change is needed? Now, I'm gone for obvious holes rather than crystal ball. Who is this? Right, Donald Trump is 72. And yet in Guernsey, most employers have a retirement age of 65. Again, why 65? In most countries, the idea of retirement at all only came into place sort of 19th and early 20th century. And 65 was actually chosen by the German Chancellor, von Bismarck, at a time when relatively few people reached that age. So that's why it's 65. Demographic changes, as we've already heard on a number of occasions this morning, are impacting upon the future of work. Particularly in Guernsey, we have an ageing population, meaning people are living longer and are needing to work longer, but also wanting to work longer. Old, non-working people are expensive for the taxpayer and an underutilised resource. The Guernsey state pension age is to increase to 67, and yet we still do not currently have any protection against age discrimination. Is it fair for retirement age, which is often 65, to be lower than the state pension age? Is it fair to automatically dismiss somebody at a certain date? In Guernsey, it is still possible to include a retirement age in a contract, which is something that was abolished in the UK in 2011. As Gavin mentioned, it's one of the characteristics that would form part of the multi-ground equalities law that's in consultation stage, but it's not in place yet. And of course, as we've already discussed, the nature of work has changed. With a greater reliance on technology and a hyper-connected workforce, age and physical state should be less important. Although again, sometimes it's used as a barrier, as assumptions can be made about the ability to deal with an ever-changing technology. And there is still little to stop an employer saying, you're past it, or this needs to go to a younger person. Diversity inclusion. The push towards diversity in the workplace is going to continue to impact on the future of work. The role of women to continue to grow in scale and importance, the rising global mobility of workers, new technologies, are all bringing together different and sometimes conflicting cultures, religions and languages. Tied in with diversity, the #MeToo movement has continued to gain traction, more about gender politics and less about harassment. Currently in Guernsey, we only have one protection. That's against sex discrimination. But we do have this multi-ground equalities law in consultation, which would include discrimination being prohibited for the reasons of disability, gender identity or reassignment, race, religion, marital status, age, sexual orientation and family status. But it is still in consultation stage. And so whilst there's a strong political will amongst the present states, it's not long before the States Assembly is going to change. And it's up to us as members of the Guernsey voting public to ensure that the next lot of states members realise how important that legislation is. In the recent consultation on our existing sex discrimination law, one of the key themes that came out is that we have an award based on 3 months' pay. And the general question was asked, is that sufficient to deter discriminatory practices? That same survey showed a very high number of people who said that they had either witnessed or been the victim of sex discrimination in the workplace. So I'm going to suggest that actually that very limited award is not enough to deter sex discrimination in the workplace. This is a picture of millennials. Now, this isn't just about them. This is about what they bring to the party. But actually, these guys are going to be 75% of the world's workforce by 2025. And with the millennials, all sorts of contradictory challenges and tension. Let's call them millennial characteristics. So, this is what they say. They say lifelong employment is a serious thing of the past. Nobody like you, Jessica, who worked for the same business for 21 years. Individuals increasingly want to thrive at work, be on equal terms with their superiors, organise their working time according to their own desires and constraints, negotiate tailor-made working conditions. 9-to-5 work days are over, if they ever were for anybody. People want agility and flexibility and a greater expectation of work-life balance. Now, faced with growing complexity and performance pressures in the work environment, individuals are asking for a more suitable balance between work and private life. But at the same time, we are ever more connected to the workplace, and the downside of working outside of the office in terms of isolation and lack of supervision is increasingly being reported. Now, in several European countries, attempts have been made to give employees the right to disconnect from their workplace outside of hours. For example, in France, they introduced a law in 2017 which suggests that every employee must have included within their contract a negotiation of how they are going to be able to be contacted outside of work and outside of work office hours. So that's a negotiation they're supposed to have at the beginning of that contractual relationship. And similar sort of provisions are also being considered in the US. Working for one employer for the many years, Jessica, is seen as increasingly a thing of the past. Portfolio workers, like my husband, where someone has all sorts of different sorts of work, but is not an employee at all, or is only an employee for one part of it, is an increasing phenomenon. But in Guernsey, there is very little protection for the self-employed or the contract or agency worker. And actually, we don't have a concept of a worker as opposed to employee, where there is some protection created to protect more casual arrangements, as they do in all other EU member states. So, do we need to rethink legislation so that actually it protects individuals as opposed to their jobs, which is what our current relationship focuses on? Tied in with these changes in the way work works is a greater awareness of the importance of good mental health and well-being. And again, employees are looking to their employer to consider well-being in the workplace, not only in how and what they ask of an individual, but how they treat someone with a mental health issue. Now, as I said in my list, we do have unpaid maternity leave and adoption leave, and most employers consider it a wise business move to pay at least a substantial part of it. But parental leave, which is non-gender specific, is still not in place in Guernsey. Whilst maternity leave is a great step forward, not until paternity leave is properly embraced will we have the significant strides that have been made in Nordic countries, particularly, say, in Sweden, be replicated here. Now, in Sweden, a couple is allowed 480 days of paid leave for each couple with a new baby, and 90 of those days is reserved for the dad on a use-it-or-lose-it basis. This policy gives a powerful incentive for fathers to take time off work, and mothers in Sweden now take 75% of parental pay compared to 99.5% in the 1970s. Really importantly, parents say it's transformed national attitudes to childcare and gender. Now, in Guernsey, there's no statutory basis for requesting flexible working, save on the basis of indirect sex discrimination. And although many businesses will consider offering flexible working arrangements for returning mothers, embracing a principle of flexibility for all, not just linked to childcare, would be a significant step forward. Of course, there will be a continued increase in the reliance on digital technology, and we've spent a lot of time talking about that this morning. In the area of financial services, there's already been a vast number of laws which govern the regulation of financial services business, and this is in a constant process of being revised to ensure compliance with relevant international standards. Tied in with laws regulating business is the draft Financial Services Business (Enforcement Powers) Bailiwick of Guernsey Law 2017, very good title, which is subject to consultation, actually for the first time deals with a whistleblowing policy and whistleblowing legislation to protect employees. And so for those of you who don't know who this chap is Jez Staley, who chief exec of Barclays, who tried to track down a whistleblower to find out who had blabbed and actually suffered very painfully financially as a consequence. So the state is increasingly expecting employees to call out bad behaviour. So this is actually a prime example of a growing tension, on the one hand, between transparency, whistleblowing, call out bad behaviour, and the protection of laws such as that data protection gives of privacy. And of course, as it's already been mentioned in the first talk, that's not the only demand on transparency in terms of certain sectors of our society in particular, and how the law deals with that will be very interesting. So I asked myself, what about another area where perhaps some parts of the world have taken a legal route and other places have taken a different route? So I decided on quotas. So let's start with a starting point. Diversity is a competitive advantage. There are multiple pieces of data reports which show that diverse businesses do better than non-diverse businesses. Now, in 2008, Norway obliged listed companies to reserve at least 40% of director seats for women on pain of dissolution of the company. In the following 5 years, more than a dozen countries set similar quotas, some at 30%, some at 40%. So Belgium and France and Italy, again, if you fail to comply with that, you can be fined, dissolved, or banned from paying existing directors. Germany and Spain and Netherlands opted for a soft law quota with no sanctions, and Britain opted for guidelines. And these are the results. Well, that's a graph, but if you ask people, has it been a success? I'm afraid it rather depends upon who you ask. There is evidence to suggest that in a business context, a quota system appears to have been effective for company boards in Norway. As you can see from this graph, there's an approximately 15% difference between the number of women on UK boards and in Norwegian boards. However, the evidence also demonstrates that the effectiveness of a quota initiative is more complex. It depends on a whole number of factors. For example, quotas are much less effective if they aren't actually enforced by sanctions. One study found that serious sanctions, particularly in Norway, were responsible for its success. However, another study said, although it helps women break that glass ceiling, it's only true for a small elite group of women who serve on multiple boards and have a lot of social capital. The same studies do acknowledge that that may be a short-term effect and that women may be able to follow in the, I think, rather patronising phrase, the so-called golden skirts. So I ask myself again, is law the answer for the fitness to be fit for the future? Well, in the UK, they've not been shy of introducing new employment law, and so in theory it should be a much better place for the future. For example, in relation to gender pay, there was a great focus on that when the gender pay legislation was introduced, which we don't have, but the gender pay gap remains. There was a huge focus on being flexible and agile. But is it better than here? Is employment engagement actually any better? In Guernsey, perhaps rather than law, our enforcement practices are perhaps more significantly influenced by the need of employers to make themselves attractive to employees. Good employees will move to an employer of choice who offer workplace fit for their future, and that will give them competitive advantage. That's what needs to happen in a full employment jurisdiction like ours. Plus, we also have the advantage that many employers have operations in other parts of the world, which also influence the culture of our workplaces. So, perhaps rather than is employment law fit for the future of work, the question really should be, are our institutions and workplaces and culture fit for the future of work? As well as legislation around demographic and diversity issues, focus also needs to be given to how practically an inclusive environment is in every single workplace at all different stages of the career. Flexible working and agility are important, but this should not be at the cost of employees feeling not part of a team. Employee engagement, training and support are at least as important as the legislation we adhere to. Data protection and regulatory legislation are crucially important, but this must go hand in hand with employees feeling engaged with the business such that they are motivated to protect the business. I would say again, of course, employment law does need to be constantly evolving to set the legal parameters for working conditions. But the culture and practices within our business must also evolve if our businesses are to be successful in the future. Waiting for employment law to change excuses employers and business owners from taking responsibility themselves. Business owners do not wait for the government to legislate on the introduction of innovative technology until they install something that could give them a competitive advantage and to future-proof their business. And they should treat their employees in exactly the same way. The question should not be employment law, is it fit for the future of work? But employers and business owners of Guernsey, is your organisation fit for the future of work? There we go.